Division 1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in May against Avila, our cause number 1CA CV130690. Counsel, as you're probably aware, we have reviewed the briefs and discussed the case before coming into court this morning, so you can bear that in mind as you begin your presentations. We are being video recorded, and eventually the video recording of today's argument will be disseminated online, so if you'd do us the courtesy of announcing your name and that of the client you represent when you approach the podium, we'd appreciate it. Each side has 20 minutes for oral argument. And the appellant may reserve as much time as you wish, subject to watching your own clock. With that, we can begin.
Thank you, Your Honor. May it please the court, my name is Stanley David Murray. I'm representing the appellant, Kelly Diana May, who was the petitioner in the lower court proceedings. I would like to reserve 5 minutes of my time for rebuttal. As the court is aware, this is a modification of spousal maintenance case. I know this court is loath to set aside orders regarding spousal maintenance orders for the reason that it's subject to the abuse of discretion standard. But remember that the abuse of discretion standard requires a showing that the order that was made was supported by the evidence, that there was substantial evidence to support it, and that the resulting ruling was not based on any error of law in the application of law. We feel those two prerequisites have not been met here. Also, this case involves findings of fact and conclusions of law pursuant to Rule 82, giving this court better option to review the findings that were made to see if they were established in the record to support the eventual ruling. The problem we have in this case is that the findings that were made did not result in conclusions to establish why modification was made, not only for only a 3-year period instead of an indefinite award, but also in the amount of only $1,800 a month, reduced from $2,300 a month. The court made no findings or explanation as to why it was reducing the award from indefinite to 3 years rather, but we do have a hint in the record to suggest that maybe the court had misapplied the law. The court seemed to be concerned about the indefinite award, and I discussed with the attorneys, you know, this isn't a medical situation. This doesn't involve any kind of permanent disability. Why the open-ended spousal maintenance award?
Well, counsel, didn't the court have the right to ask about the circumstances regarding the original award? Wasn't that?
Yeah.
And was it out of bounds to ask about?
Out of bounds to ask, but I believe it was out of bounds to conclude that we don't give indefinite awards unless there's a medical disability.
Well,
I think that's
I'm
what
not sure that was the conclusion the court reached. In fact, it seems to me that the original award contemplated, it was expressed in indefinite terms to be sure, but it expressed as one of the reasons for that your client's educational goals, the anticipated time it would take, the necessity for her to make progress toward those goals so she could increase her income. And if that was the contemplated purpose of the original indefinite award, why isn't it satisfactory simply for the court to say there's been progress toward the educational goals, there's been an improvement in economic circumstances, and there's been a corresponding decrease in your client's cost of living, and a decrease in your opponent's income. Isn't that enough?
Because the court didn't explain why it was reducing that award from indefinite to 3 years.
Well, but the court did make the findings that I just outlined.
It certainly did.
And I think you and I both understand what I'm saying. Those findings translate to a conclusion that an award may be justified. Are you looking for certain magic words in the form of a conclusion of law?
Yes, sir, because findings of fact and conclusions of law were requested. It's just like in the Hughes case. In the Hughes case, the court reversed the trial court for giving an indefinite award without explaining why. Vice versa here, we have an award that was indefinite that's now being reduced to 3 years without an explanation.
Let's keep in mind, so if I understand correctly, the father requested not for a reduction, but elimination of the award. That was the petition, right?
Yes, sir.
That's
complete
what the
termination
request
is what he was requesting.
So So couldn't the court hit any target between rescinding, or completely rescinding the award, leaving it indefinite, or anywhere in between?
It certainly had that discretion, but based on this record, that discretion was abused, is what we're saying. And the reason I say
Simply because
that,
but what magic words? What more could the court have done here? What could Judge Dunn have done in addition?
well, she needed 4 more years to complete her bachelor's degree that could have resulted in a higher management position with SRP. The court could have found that she only needs 3 years to do that, and that would put her at that point where there doesn't need an indefinite award anymore. What I'm saying, there hasn't been a change in circumstances to indicate the indefinite award should be reversed at this point.
But given her dramatically improved economic circumstances, what's the nexus now between an indefinite spousal maintenance award and her need to complete a few more credits of a college education?
Certainly. The retirement planning, Your Honor. Recall that from the original Court of Appeals decision in this case, the purpose and the arguments that were made at the trial court in the original trial was that the parties didn't have enough accumulated retirement benefits. They split $52,000, I believe it was. Part of that award that was made initially was to allow her to build up a nest egg, build up a retirement account.
Which she has done.
Not any degree that it's that substantial and continuing. At least there wasn't any finding that it was.
But she has built up substantial wealth over the course of the period since the decree was entered. In other words, this is hardly maintenance in the dictionary sense anymore. This is improvement. And was the court not empowered to take that into account?
Well, when you look at improvement, there's 2 ways to look at that. The rainwater case, remember when that first came out, we looked at spousal maintenance as either rehabilitative or restitution. Rehabilitative was the primary goal, to get the spouse back on her feet, so to speak, back into the work environment. But there's also a restitution element here. And the argument that was made back in the first trial was mother's need to invest money in real estate, in retirement plannings, which she did through real estate. She's actually increased her expenses because she had a $13,000 loss in 2012.
It troubles me. I was going to address that with you. The assertion that divorced spouses are somehow responsible for maintaining one another's investment security years after the divorce is highly troubling to me. That seems inconsistent with the entire intent of Title 25. How is one's former spouse supposed to be a guarantor of another's investment success, especially over the period we've been dealing with, where a lot of investments have not succeeded?
That wouldn't be the proper inquiry, I agree. But the fact that this order was based on a restitutional type basis, and that restitutional basis hasn't been met yet because she hasn't secured enough retirement benefits yet. She hasn't secured a standard of living.
Enough for whom?
How do you define enough, counsel?
Yeah.
Enough would be where she could afford her lifestyle right now. She's got expenses of over $7,000, $8,000, I believe, and she's only earning $5,800 a month right now. There's still that discrepancy. There's still that difference in income and expenses. Plus, she still hasn't achieved her educational goals. I don't want to just focus on one particular factor. We need to look at all the factors that are relevant.
But the $7,000 or $8,000 in expenses she has are somewhat self-imposed, aren't they, at this point?
Certainly. But
so
again,
it's his continuing obligation, it's husband's continuing obligation to offset the post-marriage expenditures. I mean, aren't we back to the same thing Judge Swan was asking about? It's his job to make sure that she stays at that level regardless of what she does or what she expends or whether her investments are good or bad investments. And the question I had was, if she has a windfall in regard to these investments, does he have the right to come in and take a portion of that because it exceeds the retirement expectation she had?
To answer your last question, if she does have a windfall, then that would be a chance for a modification, for a change of circumstances that would be substantial and continuing.
But wait, you're saying a change of circumstances. I'm saying if she has a windfall in her earnings on her investment monies that he's offsetting her debits for in the meantime, does she then have a corresponding obligation to pay him a percentage of the increase in the values of those properties?
No, sir, I don't believe so.
So he's responsible for the downside of her investments, but has no share in the upside?
If there was an upside, I would imagine the modification would be justified, but there
The
wasn't an
modification,
upside.
but the best case modification would be the end of the award. So if she suddenly becomes a multimillionaire off these investments, he doesn't get any of that, but if she loses money, he's responsible for maintaining it? That seems unjust.
I understand. What I'm trying to say is that she hasn't reached the restitutional goal where she can support herself, and that's what the initial intent of that order was.
Well, I know, but that's what you were saying before Judge Jones and I asked you these questions. Now that these questions are on the table, how do you reconcile your position with the facial inequity that you've defined?
Because that didn't happen, the increase in value didn't happen, the windfall didn't happen.
But we
in this
deal with
record right now.
Counsel, we deal with points of law and issues of law that go beyond this case, obviously.
Certainly.
And so we can't say that if we were to accept your premise that he's obligated to offset the deficits that are accruing to her income at this point because she's made investments that maybe someone else wouldn't have made, but it's his job to float her on those. We can't say that it's just limited to that, and that down the road it couldn't be flipped over to be told that, well, the gains will be dealt the same way that the deficits are, correct?
Right. If those gains happened, I would agree that there would be no reason to keep the spousal maintenance in effect.
Well, but again, you're saying there's a reason only to the extent that he covers her losses. She's not responsible to give him any of the gains. But when he gets a severance package years after the divorce, she's entitled to a piece of that. I mean, it seems to be a very one-sided perspective you're advocating.
If she had
He
gotten
also
a
seems
piece
to
of
be
that
being made the
severance-
guarantor, counsel. One of the things I'm concerned with, he appears to be being made the guarantor of her future success.
Well, the
So
spousal
please, if you'd
maintenance.
address both those issues, I'd appreciate it.
Right, okay. Well, part of an award of spousal maintenance is to support that spouse so she achieves financial freedom, financial independence. So yes, I guess he is a guarantor of her success.
Oh, no, I think the spousal maintenance award is to give her the opportunity to achieve that success.
Okay. And she hasn't yet. She hasn't got her bachelor's
She
degree
had
yet.
the opportunity, and the opportunity has borne great fruit for her. It seems that the award has served its purpose. I don't think there's any law that you can cite that says that a spousal maintenance award persists to guarantee the success without holding the other spouse accountable at all for her actions. I mean, she could have finished her degree by now, but she hasn't.
No, she was taking part-time because she's working full-time, and then
I understand, but it's been a while, and she has made less progress than the initial judge anticipated by my calendar calculations. She didn't need to make the investments that she made, and he, of course, has no control over what investments she makes. She could invest in lottery tickets, and if they don't pan out, he's responsible for buying more lottery tickets. That's a dangerous proposition of law, I think,
All right.
don't you?
I don't know if I go that far with the lottery tickets, Your Honor, but
Counsel, doesn't one of the briefs also say that she's decided at this point that completing her university degree isn't in her plan? It's not part of her planning for the future at this point?
that was one of the findings that Judge Dunn made, but it was incorrect, and that's why I'm asking the court to review the record to see that she wants to be promoted at SRP, and she can only do that by getting that degree. And so I don't know why the judge found that she's satisfied where she's at, because she's not satisfied where she's at.
Well, the judge may have been expressing the same concern I was, that she's made less timely progress toward that goal than was anticipated at the time of the award.
And that's fine, and that should have been in here. That should have been his conclusions of law, if you will, as to why he was modifying this award. That's what's missing here. I mean, we can speculate about all the other possibilities that could happen here, but she hasn't attained her goal. She's not financially independent where she can support herself. That's why the award is still in effect. And by the way, the judge never did make a 319A finding, but we can imagine or assume that it's based on the fact that she hasn't reached that level of self-support.
Well, 319A, what relevance does 319 have A in a modification?
Because the court has to review the circumstances that led to the initial award to make sure that there's still a basis for an award.
That may be a be careful what you wish for argument. I mean, if we remand for a 319A review, your client could find herself not getting to 319B.
Well, I suppose that could happen, but just considering that Judge Dunn did rule that she's still entitled to spousal maintenance, I'm assuming he would make that same ruling that she does qualify under 319A as Judge Gentry Lewis did initially. My time's running out, but I want to cover real quickly the attorney's fees award. The court, again, findings of fact and conclusions of law, simply stated that father has more financial resources than mother does, and that neither party was reasonable. I know the court has discretion.
Neither party was unreasonable.
Unreasonable.
Unreasonable, I'm sorry. Neither party was unreasonable.
We are listening.
I'm being unreasonable, aren't I? The award of $3,500, though, doesn't justify the amount of time that was spent on this case, and the positions that the father had taken led to this litigation. The award, the requested amount was over $17,000, and I don't understand how the court can have that much discretion to determine $3,500 is a worthwhile fee. And finally, on the
But
issue,
Chris, you wouldn't. The court could have awarded none.
the court, if it made the finding
You
of financial,
disagree with that. The court could have awarded zero.
I know the Myrick case that recently came out seems to say that you don't have to award attorney's fees. But if the court is going to make an attorney's fees award, it has to be reasonable. It has to be based on the evidence that was presented. And my client showed that he has 3 times the income that she does, especially in 2012 when he got that significant windfall from the severance, which the court did note in its determination.
Severance, how is a severance a windfall? Severance is the loss of your job, and payment for, I mean, in this case, it was payment for accrued vacation and other income that he had actually earned, and then he lost his job. I think calling that a windfall might be overly optimistic.
Well, in terms of his pleadings, though, his petition said that he has no more money, that he changed the circumstances in his financial circumstances, when actually he found a job shortly thereafter for $120,000 a year plus the $100,000 plus in the severance benefits, to show that financial disparity existed in 2012 when the petition was filed. Which brings me to the last issue, and that's that severance package. I know it doesn't fit into the square peg round hole type analysis as this as a newly discovered evidence, but there's nothing about omitted evidence that requires, omitted assets, that requires that evidence to have existed back at the time the decree was entered into. The evidence suggests, the record suggests, that this award of severance was based on past services.
But how does that make it omitted evidence?
Omitted asset?
Omitted. You said omitted. It was omitted evidence from the prior hearing?
Right, because it wasn't dealt with. There was no, well, you know how we have those catch-alls and decrees about employee benefits, retirement benefits, or go to the party in their name. There was no finding in that regard. So we don't have a catch-all provision to cover that circumstance, that possibility. So because it was based on past community earnings, past community services under the Brebaugh case, even though it involved stock options, we believe that provided grounds, at least for a hearing, to determine if there was a community interest there.
Well, are you saying that the community's interest in stock options would be similar to his buyout on any future interest in his job?
If they were compensating him for his past services, rewarding him for his past services, which seems to be the basis.
Let's say he didn't have a severance package. Let's say he got a really handsome bonus based on his long service to the company. Does she get a piece of that?
If it's calculated based on the amount of money that he earned during the time of the marriage, I would say so. It's just like
well, what if it's just a general expression of gratitude for long and productive service, and they give him a $100,000 bonus?
Well, under
does
the
he
Brebaugh,
owe that bonus to his former spouse? That we're not allowed to reopen property provisions in decrees for a reason. That's what the legislature has told us.
correct.
And it sounds like you're suggesting that we should hold that as long as there is some colorable basis to believe something during the marriage affected the future prospects of a spouse, that they're always subject to reopening.
Because we have to look at the employer's intent on any kind of a severance, bonus, or any kind of employee benefit that wasn't awarded in the decree is why we're considering this an omitted asset. That
So
needs
if
to
it
be
was
developed.
just waiver of the right to sue, then she would have no right.
If it was a catch-all that said he gets his employee benefits, she would have no right. But there's evidence here that needs to be developed to determine if this is based on community services, is what I'm saying. I'm going to save my time for rebuttal unless the court has any questions. Thank you, Your Honors.
Thank you, and good morning, Your Honors. I am David L. Rose. I am appearing on behalf of the appellee, the respondent at the trial court level. I appreciate your time this morning. The court asked right off the bat if this was a 319A case, and as the court correctly notes, we did not cross-appeal arguing that there was no satisfaction of 319A. So I would tend to agree with the court that it really has no relevance as to whether or not wife was entitled to receive spousal support or not. Essentially, we waived that argument on appeal despite the fact that perhaps we could have made it based upon the circumstances. The proper inquiry into this case is whether there's been a substantial and continuing change in circumstances, and the court can answer that question by asking itself two things. Is the record devoid of competent evidence, or to put it another way, was there clear error in the manner in which the trial court judge conducted the proceedings and made his findings of fact? There were many changes in circumstances, as the court has already noted. Husband lost his job. His income went down. Wife's income went up over the years. Wife's child support obligation to husband went down over the years. In fact, if you add up the increase in the amount of money wife made from her job changes and the increase in income she got from the child support, that's at least equal to what husband's spousal maintenance obligation were. Wife bought 3 or 4 houses that had positive cash flows. She received income from her live-in boyfriend. She was depositing significantly more money into her retirement accounts. So the argument that one of the reasons that she should continue to receive spousal support to contribute to retirement is simply erroneous. She is contributing to retirement, and she's contributing more.
What about the argument that he needs to help her offset the loss in income as a result of her investments?
Your Honor, I would agree with the court's argument. There is no obligation for a former spouse years after a marriage is over to continue to try and support the other spouse if they make bad investment decisions. But that isn't even the case here. She made a bad investment decision on one of these properties. The other properties have positive cash flows, and Judge Dunn correctly noted that she actually has a positive cash flow resulting from her investments.
Didn't someone note that she wasn't getting rid of the properties because if he was able to offset long enough, the value was going to come back?
Yes, sir.
And that they would then be positive cash flow.
That's exactly what the wife argued at trial, or the husband argued at trial, and the wife admitted. She bought these properties for the purpose of having them grow over the years. It's no different than a stock account. You might have half a dozen different stocks in your portfolio. Some may go down, some may go up. The long-term importance, though, is that they're all going to go up over the time. That's the reason that you invest in them.
But my point is she's not interested in getting rid of a bad investment right now.
Doesn't seem that way.
But wants him to offset in the meantime until the value goes back up to where she wanted it to be absent the recession.
I agree. That's what she wants.
Okay.
I completely agree. That is what she wants, and that is certainly not fair and equitable, and it's not one of the justifications that the legislature set forth under 319B for a reason to get spousal support. You simply can't say, oh, I made a bad investment and therefore I get spousal support.
Counsel, did the court make sufficient conclusions of law here? And specifically, I think you'll agree that the court did not specifically say, as Mr. Murray pointed out, why it was awarding 3 years as opposed to 4 or 5 or keep leaving indefinite. The court did not explicitly say. Number one, did the court or need to?
I don't believe
Arizona law.
Thank you, Judge. I don't believe that the court needed to. Once the court made the conclusion that there had been a substantial and continuing change in circumstances that had occurred, it then had the discretion to do a number of different things. It could have denied husband's request to modify it altogether based upon the then existing financial resources. In other words, just because there was a continuing change in circumstances doesn't necessarily mean that it's going to be a modification. The court could have technically terminated the spousal support award at all. The court, in this case, decided that based upon the Hughes case, The intent of the original spousal maintenance order had been entered. In other words, wife was self-sufficient. That's what the purpose of spousal support is, and that's what this court obviously found when it made a determination that either she was self-sufficient or she could become self-sufficient within that limited period of time. Mr. Murray's argument that the trial court cut her off at 3 years' worth of spousal support is simply erroneous. This was an 8-year spousal support case. Wife initially got support in 2006, I believe, and it's ongoing as we speak. So it's not simply a 3-year maintenance case. The court looked at the law, looked at the facts, and made a determination that wife was going to become self-sufficient, or in fact was self-sufficient. I'd like to comment briefly on the findings of fact that the court did, because there was a lot raised in the pleadings regarding the court's failure to go through the findings of fact. I simply cannot agree that the court did not specifically go through the elements in 319B. In fact, if you look on page 3 of the under advisement ruling, the judge goes through in detail why he made these findings. He made a number of details regarding what the incomes were, what the incomes could be, what the educational issues were, what the insurance issues were, what the retirement issues were. After the motion for new trial was found, he then was filed. He then went forth again and set out in detail the reasons that he made these adjustments to wife's spousal maintenance program. So there were substantial and continuing change in circumstances. The trial court clearly went through the elements of 319B and, as Mr. Murray commented in his brief, didn't just comment on them, but specifically analyze them, which is required once a request for findings of fact are filed. The change in duration, as Judge Brown asked me, really is allowed because once the court determines the issue of whether one party or not is capable of self-support, that's all that matters. It doesn't matter anymore that the court has to make a determination as to why it's going to do it in 2 or 3 years. As Judge Swan suggested earlier, the court could have simply just cut it off entirely. Husband's severance account, like this court mentioned, it's not a windfall to husband. A severance payment is something that compensates you for the loss of your job going forward.
How is it defined in its being given? How is it defined?
There's no evidence in the record to support that question, Your Honor. I can't answer that. Wife has said in pleadings that the severance was paid based upon some formula that she believes exists, defined by the amount of time husband was married. There's nothing in the record to support that.
How long he was married or how long he was employed?
How long he was employed.
Okay.
There's no evidence in the record to support that. There's 2 pieces of evidence that are cited to in wife's opening and reply brief with respect to this. And both of them are her own self-serving statements in her own pretrial statements where she makes these allegations. But there's nothing else in the record. Yes, sir.
So we're clear. There's nothing that says this is compensation based upon seniority or tenure or the loss of position built up over time versus this is to offset future monies you would have made had we not found your termination necessary and appropriate at this time.
That's correct.
Zero distinction between those two drawn.
Yes, sir.
Thank you.
Yes, sir. So, and I think her citation to the Reniger case is completely misplaced. Reniger was a case where there was a pension that existed that wasn't discussed in the decree, and Reniger wasn't filed 7 years after the fact either. This court clearly holds that pensions are community benefits, but severance benefits, as a matter of law, are not community benefits. They are to compensate someone for the loss of their income. This very court has said so in the Marriage of Crawford case. So I just simply think that when a wife comes in and makes an argument kind of fishing for money that she has no right to, the court has a right to cut it off at the pass and grant a motion to dismiss. The attorney's fees issue is the same issue. The trial court has to look at the incomes of the parties, at the assets of the parties, at where the parties are in their life. Wife continues to argue that husband's windfall in the severance is enough so that his income is sufficient that she should have been granted a larger amount of attorney's fees. That's not true. The law is very clear that you don't count these kinds of windfalls for income. And the law is also very clear that you don't just look at income when you're making a determination of the payment of attorney's fees. You look at the overall picture, income, assets, retirement accounts.
I believe the statute is couched in terms of resources.
It is resources, and that's my point, Your Honor. The resources are greater than just the income. Even if you assumed husband made more income than wife, wife clearly has more resources in this case than did husband, and the trial court judge was in a better place to make this position in the first place. He was able to look at the credibility of the parties, review their financials, and make these decisions. Certainly, husband had to expend a significant amount of attorney's fees also going forward with this process, and the trial court would be presumed to have looked at the monies that he expended when he decided that wife was entitled to a portion of her fees. It's certainly
I imagine
not.
the total fees expended probably approximate or exceed the value of the maintenance that's being sought.
Your Honor, in many of these cases, it's an unfortunate fact of life, but sometimes the legal fees exceed the benefits that are gained by the parties. I have nothing further for the court. Thank you for your time.
Thank you.
You know, where is the finding of substantial and continuing change of circumstances? Because there were findings of fact and conclusions of law, this court is not expected to infer that those findings were made. They have to be stated and they have to be demonstrated from this record. I kind of equate this with the child custody modification cases in Reed versus Reed, where the court said, hey, not only do you have to make these findings, you have to explain to us why this modification of child custody is in the child's best interest. That same logic and reasoning, I believe, applies to a spousal maintenance award when findings of fact and conclusions of law are requested. The record is devoid of that.
Mr. Counsel, I guess I have to point out, you'll agree with me, I believe that on the child custody matters, the legislature has made it very clear how those findings are to be included, as opposed to spousal maintenance. There's no such requirement.
And there's a substantial difference between affecting the life of a child and an award of money. The award of money resonates with civil considerations more than the custody of a child.
Well, certainly, Your Honor, but again, under the Elliott case, findings of fact and conclusions of law are not usually required in spousal maintenance cases, but if they are requested, then you got to make those findings. And so, yes, it's not the same as a child custody case, I agree. The statute does say specifically, give us your reasons as well. But I think that same logic should apply to a spousal maintenance, because my client's financial status is being affected detrimentally, especially since it's been lowered, and also for a shorter term. We keep talking about the wife's financial circuit. Oh, my time is up. I'm sorry.
Thank you both.
Thank you,
for your arguments. We will take this matter under advisement, issue a written decision in due course, and we'll stand in recess to allow the next argument to set up. Thank you.